Good morning.
Morning.
It's great to see so many familiar faces out there. Before we get started, I want to get a sense of who everybody here is, and so I'm going to go around and ask every single person to. But I want to get a feel for who we are, and then I'll introduce our panel here. So first off, who here is from a public agency? Who is from Caltrans? Anybody here from Caltrans? Oh gosh, now I can't say what I was going to say. Yes. How about OPRs? Anybody here from OPR? Excellent. All right. Who's here from the private sector? And how many people are attorneys? 3. Okay. 4. All right. So if I say something about the legal profession, I apologize in advance. As far as years of experience, 0 to 1, 1 to 5, okay, 5 to 15, and then yeah, experience too much, and 15 plus. Wow, we got a seasoned group here. Okay, so that is great. Well, let me introduce the speakers. I'm Gary Jacobs. I'm a principal and a founder of Ascent Environmental. And I've been practicing CEQA for 30 plus years. On the panel here is Pat Angel with PMC. Just checking. Pacific Municipal Consultants. There's some news surrounding that, but I won't be the one to talk about that. Pat, how long? You know, that's my job. And Pat is a fantastic person to have on the panel. He not only has his own CEQA practice, but he works very closely with a lot of cities and counties on implementing their CEQA practice. So he has some very good hands-on experience to share with you from his practice. And then Jim Moose, who has been practicing law for 29 years. Jim is known as the George Carl of the legal profession. He wins a lot more than he loses. He is a true expert in CEQA. A lot of case law that has been published has his name on it as attorney of record, and he's going to bring some very good experience and knowledge. In terms of what you're going to hear today, it is going to be a very full session. For case law, we're not going to go through every single case that was decided over the past year. We're going to focus on the top 10 or 11 CEQA cases that really influence the practice, provide clarification on how to address a certain issue or a certain procedure, or that highlights a division in the courts on how to address an issue. So we're going to focus on really the most relevant cases. We're talking about administrative records, what's due, what you should say, what you shouldn't say when you're preparing your environmental documents, what to do with emails, things like that. Then we're going to be talking about transportation in SB 743. One of the biggest changes that we're going to be dealing with in CEQA, really over the last 25 years or so, could be coming up, and we're going to talk about SB 743 and what it means in terms of transportation. Then we're going to talk about we'll have lunch, but then we'll talk about legislative update. There's really only one bill last year that is relevant, that's AB 52, dealing with travel cultural values. We talked about that. Mitigation versus project design, controversial case last year, Lotus versus Caltrans. Can you incorporate project design features into the project description that also mitigate impacts? So we'll talk about that. Water supply. Guess what? There's a drought. Also, last year, in response to the drought and recognition that California was the only state, pretty much in the country, that didn't do this, we passed landmark groundwater sustainability legislation. How does that ultimately relate to the work that we do? The legislation was exempted from CEQA, but does it affect how we do water supply assessments? So we'll be talking a bit about the drought, but more importantly about groundwater sustainability plans and how to do a water supply assessment. And then we're going to close it off with this this session we're calling CEQA's Edges. There are how many cases, Jim, before the Supreme Court?
9.
9 cases before the California Supreme Court on CEQA, some of which could have a dramatic effect on what we do and don't cover in CEQA, some of which are procedural. So we're going to be talking about that more, not in terms of the details of the cases so much as in terms of what it could mean if the court goes in certain ways. And then we'll have questions and answers. As the speakers are presenting information, please feel free to raise your hand, ask questions, ask for clarification, get in some dialogue. This is a much better session if we hear from you than if you just sit silently and sit on your questions. So we'd certainly like to hear from you. And with that, we will, well, here are your curriculum prepared. By the way, I serve as the volunteer curriculum director for this. The people who put together this show put an awful lot of work into this, and you're going to see a lot of slides, a lot of very rich information, some of which we'll go to in the detail on the slides, some of which we will not. These folks have worked over the holidays to prepare this, so Jim is one of those people. You'll see names of others up here. Give them a hand because this is a labor of love to bring this show to you. And with that, Jim's going to start with case law.
Well, good morning, everybody. Thanks for that laugh on the labor of love issue. I'm not sure if it's labor of love or I felt it. Is this turned on? I'm going to start out by disclaiming my credit for the slides in your final form. It was very generous of Gary to keep my name on them, but actually my slides are in the back. And the reason they're not here is there turned out to be about 400 of them, so I got a little carried away, and we realized we couldn't get through 400 slides in an hour and a half. But my hope is that they will provide a useful resource for you all. If anyone actually wants to get into the real nitty-gritty of the cases, my hope is that if you read all these 400 slides, you won't need to read the cases. So I'm going to do them from memory here. This is really Terry's work product, and what he did was looked at my incredible overkill and distilled it to its essence, which is the talent he has. So I just sniped it up in terms of what you actually see here. He's the primary author of these particular slides. So there were something like 26 court cases last year, which is about what we've seen in the last several years. In part, that's a function of the phenomenon of unpublished cases being readily available to the public on the Court of Appeals website. And so there are people like me and some of my colleagues who troll through the unpublished cases. And if we like them, we then write letters to the courts and respectfully beg them to publish. And it actually works pretty well. In the past, there used to be an overabundance of published cases where petitioners won. And it seemed to be that the courts thought, well, if the petitioners win, it's a worthy precedent. But if the agency wins, it's no big deal. Why publish? Those of us who typically defend the agencies took issue with that. We think it's very helpful for the courts to publish where something was done correct, and that therefore you can then try to duplicate that in the future and be able to defend your work product. So there's a larger number of cases than there used to be, and I think there's a much larger percentage of the respondents winning than there used to be. So there's maybe a sense that the tide is shifting towards the defense, but I think it's in part just that there's more published cases where the defense side is winning. So of those 26 or so cases, Gary asked me to come up with a top 10, and I figured there's probably hardly any lawyers in the room, so it was easy to get rid of a bunch of cases on statutes and limitations and stuff like that, which I'm sure is in no interest to you. And then I just try to figure out what cases, unless the other ones, would actually affect the daily practice of CEQA. And I was aware that there are certain cases that are being dealt with in other sessions, in particular the Lotus case. Had we not had a session on the Lotus case, it certainly would have made the top 10. So this is just sort of an introduction in terms of what the topics have been. Exemptions have been getting a lot of attention, not so much on neg decs this year, but a lot of EIR cases. And the trend in EIR cases seems to be for very long opinions, sorting through lots of issues. So you're seeing 70-page opinions a lot, and of course just working through all the claims that the opponents have made. And so there's a lot of law that's coming out of it. And hopefully the courts are giving useful instruction on how to write EIRs and to pitfalls to avoid. These are new batteries. I just see your new batteries. You've looked at stuff all oh well. Someone gonna help me. I don't know if anyone could be kind enough who's sitting here in the projector to advance. Some technical challenge here. Thank you. Man, stepping into the breach is a true heroism. He sees a need and he's someone drowning in the cold, icy river. This gentleman. That was almost a destination. So you find the arrow on the sheet.
Well, I found the arrow, but it is not responding. That might be the problem.
All right, well, let's see if we can do this entire day from memory. I'm just going to maybe I'll go to the 400 in the back.
I guess you can chomp on that. That's weird.
Okay.
Okay, well, thanks very much. Anyway, I think I kind of anticipated this slide. I was talking about just be the top 10 that works for them. Okay, thank you very much. We did get a chance to see true heroism in action. Not in vain. So anyway, these are the topics that I'll be touching on. I'm trying to go in a logical order, dealing with the cases first that deal with the early parts of the CEQA process, then moving into the full EIR mode, and then I'm not going to get to much litigation. So hopefully the order makes sense. It's not chronological, it's based on the category. So first issue, are you even subject to CEQA? These cases deal with exemptions. So the way these are organized, there are references to cases that you won't hear me talk about now, but that are in this 400-page compendium I've done, or that are going to be talked about in other topics. So there's a case that came out called Trends of the Eel River. That has been taken up by the California Supreme Court. We'll talk about that at the end of the day. The second case is one that didn't rise to the level of being the top 10, but it's in materials. And basically, the little blurb there is basically holding the case and to deal with whether CEQA applied to Governor Brown's concurrence in a decision by the federal government to create a tribal homeland for a tribe that wanted to start a casino. And the petitioner was the opposing tribe that already had a casino. Tuolumne Jobs is a California Supreme Court case that came down. It's not pending. It's an archaic issue dealing with election law. Basically, if a citizens group submits a qualifying initiative petition, the agency can directly enact it without complying with CEQA under that case. So I will talk in depth about the North Coast Rivers and the San Francisco cases, the Citizens for Environmental Responsibility case before the Supreme Court, the State of Plastic Ban case. I'm not talking about it in materials. So this first case, North Coast Rivers Alliance. This one I think is important on the issue of baseline, and also baseline is applied to the statutory exemption for ongoing projects, grandfathered projects. That's section 15261 of CEQA, and then the class 1 exemption for existing facilities. So basically what this case was about is Westland's Water District and some of its subsidiary districts, smaller districts between Westland's Water, entered into a 2-year interim contract with the federal Bureau of Reclamation to continue delivering Central Valley Project water to Westlands, consistent with the terms it has had in place since prior to 1970, CEQA, while Reclamation prepared or continues to prepare a programmatic EIS for a proposed 25-year renewal, and that was under the Central Valley Project Improvement Act. So the question was whether the agencies here had properly invoked these two exemptions, and the court held that they had. So much detail I'm used to my forward page slides here. So important dates, just by way of background, CEQA was enacted in 1970. In 1972, California Supreme Court issued its first decision on CEQA called Friends of Mammoth. People probably heard of it. Landmark decision. And it surprised a lot of people. I was 13, so I wasn't really tuned into it, paying attention, but I'm told by Leo Codgers, who were around at the time, that it was a big surprise because the term project was added to CEQA in the original statute, and I think the common understanding of it was that it meant things like public works projects, agency projects. So the surprising thing about the Friends of Mammoth decision was that it interpreted the word project to apply to a conditional use permit approval by a governmental agency. So it essentially said that CEQA applied to private sector. And so that created quite a furor in 1972 because there were a lot of real estate approvals that had tentative map approvals, such things that happened after the effective date of CEQA, but prior to the Friends of Mammoth decision. So people were afraid that any of those projects would be challenged under CEQA and create chaos. So the legislature responded by enacting emergency legislation that did a bunch of things. It created a short statute of limitations for CEQA challenges. There had been no statute. So in the future, people wouldn't be worried about their projects for months and months or years and years. It would be a 30-day period for people to challenge. It also essentially codified Friends of Mammoth, accepted the result in the decision, the broad application of CEQA. But it also grandfathered anything that had been approved during the CEQA era, starting in 1970 up until the end of 1972. And essentially, the language in the statute focused on land use type approvals. Now, Natural Resource Agency, in promulgating the CEQA guidelines, subsequently took that statute and the concept of grandfathering and created Section 15264, which is for ongoing projects. And basically, for those ongoing projects, they're grandfathered under CEQA unless they expand in a way that causes new impacts. So if you keep doing with these grandfathered projects what had always been done prior to CEQA and don't expand them, then you're good. And so the State Water Project, for example, was grandfathered. So the court here goes through a bunch of dates, essentially to show that this is a short and Terry Rick's water version. My slides go through a lot more detail. But essentially, by 1970, Westlands had in place contracts for approximately 1.15 million acre feet per year if the hydrology of the state is able to deliver that. As everybody knows, the amount of water that's exported from the Delta varies year from year based on how much rain and snow we get, and in more recent decades, based on environmental considerations like the need to try to limit effects on endangered threatened species. But if all things line up and the water deliveries are at their maximum, Westlands needs about 1.15 acre feet per year. And so this 2-year contract essentially locked that in. Now, the petitioners challenged that on the theory that bad things were happening to Delta, the export of water to Westlands and other places from the south part of the Delta was adversely affecting fisheries, and this 2-year continuation would continue to contribute to that harm. So those concerns came up in a couple of instances under the legal theories here. Under the categorical exemption for existing facilities, the argument was made that these adverse effects constitute unusual circumstances, creating a reasonable possibility of a significant effect on the environment, which would therefore defeat the use of the categorical exemption. And to me, what the most important aspect of the decision is from a presidential standpoint is the court's rejection of that idea. And the court essentially came out and said, CEQA is concerned about changes to existing conditions. And if those existing conditions are bad, CEQA doesn't care. CEQA is just focused on change. So even if the court were to accept, for the sake of argument, and I think as a factual matter, that exports from the Delta are having adverse effects on fish, that's part of the existing environment as we know it. And because this contract renewal wouldn't change those existing conditions other than to allow them to go into the future, the court said there was no impact. So on the issue of the unusual circumstances exception, the court said there's no impact. So we don't need to address whether the circumstances are unusual. We don't need to decide whether, we'll talk about later today, the California Supreme Court and the Berkeley Hillside case will simply say that the unusual circumstances analysis is really just whether there's a fair argument or not. The court said we don't need to reach any of that because there's no change in the environment. And so the court says it doesn't matter whether the environment includes ongoing damage, and it doesn't matter whether some of those activities locked into the environmental baseline never had CEQA. CEQA just takes the environment as it defines it. So CEQA is not a restoration statute, basically. Now, the court doesn't go into it, but it occurred to me as I read this that if this had been an EIR EIS, of course this was just an exemption, but hypothetically, if there were a NEPA analysis done for this, I think the outcome would have been different. In my experience doing joint documents, most of the federal attorneys that I've worked with take the position that the no action scenario is the equivalent of the CEQA baseline. CEQA uses existing conditions as the baseline, whereas under NEPA it's no action. So if you apply that logic here, the no action scenario would have been, suppose the contract was not renewed, the water stopped flowing, the exports from the Delta were reduced. In that scenario, I think you do a comparison of the proposed action against the no action, you'd see an incremental adverse effect under NEPA. But because CEQA uses existing conditions as the baseline, you see no impact at all. So this is an example where NEPA might be more protected than CEQA. And just underscores the fact that CEQA is not a restoration statute. CEQA just takes the environment as defined. Yeah, question?
Yeah, do you see CEQA taking that standard, that no action standard, are they likely to adopt that in the future?
I'm sorry, could you speak up?
Oh, I'm sorry. The no action NEPA standard you mentioned, do you see CEQA ever adopting that?
It would take a big change, if not in the statute and the regulations, but probably at this point it's so locked into the regulations, there's so many court cases walking in that it might well take legislative action. This was decided back in the late 90s. Baseline appeared in the guidelines for the first time, section 15125 back in 1998. Okay. And at that time there were discussions about which was more protective, a future baseline or a present baseline. And I think most people thought in most circumstances, existing conditions would be more protective. And I think that's probably generally true. Here's an instance though where I don't think it is true. But just for example, I haven't read the Keystone Pipeline EIS. I can imagine what it says, being a NEPA document. It probably says that if you don't build a Keystone Pipeline, then all that oil from the tar sands will be sent by rail somewhere, and maybe the trains blow up like one did yesterday. And so the Canadians are going to destroy their forests and take out this tar sand, and all we're doing is talking about how you get it out of there. And so there'd be no significant effect because it's just a choice of how you get that oil to port. Whereas if it were CEQA analysis, you'd look at the impacts of building a pipeline and what the footprint is of that pipeline, and you might say, you know, this will enable the oil to be exported, and maybe you take some blame for the pipeline for the greenhouse gas emissions associated with doing that. So I haven't read that document, I just heard a lot about it in the news, but you can kind of imagine how that might go. And of course, none of this NEPA stuff's in the decision. But, I thought about how CEQA and NEPA differed as I read it, so I thought it should have. So I'm going to move on to the next case. Okay, so this is a CAT-X case. This deals with Class 3, which is small structures. And so the small structures here were a whole bunch of utility boxes to facilitate fiber optic service in San Francisco. And the opponents argued that this was a misapplication of the Class 3 exemption. The actual language talks about installing equipment in small structures. There are three clauses of 15303 that create this exemption. And so the case turned on the language installation in small structures. The petitioners contended that if you built something new, if you built a new structure, you couldn't come in under that language because it read as though these are existing structures. But the court didn't agree. The court noted that other places in the same section, the word existing appeared before the references to structures, and so the court said that the Resources Agency wanted to limit this to existing structures. They knew how to use the word existing, and they did. Then there's a question of whether the use of the exemption can be defeated by the exception to the exemption for unusual circumstances, creating a reasonable possibility of significant effects. And pretty much in all CADX cases, you'll see that issue raised. It's almost automatic. If someone's challenging the use of the exemption, they'll always come at you with this exception. And the court here found that there was no fair argument. And arguably, it's a slightly activist decision, but one that to me kind of makes sense. The court essentially indicated it was concerned about the idea, excuse me, a little bit more visual clutter in a highly cluttered urban environment should trigger, full environmental review. So the court talks about the thousands and thousands and thousands of these structures that are already existing all around San Francisco, and indicated that, there was something in the record that people probably wouldn't notice these things, given all the visual clutter that's already there, everything from kiosks to newspaper stands to traffic lights, et cetera, et cetera. So you read the case, you feel like the court was thinking it was a slippery slope. If we introduce CEQA to visual analysis in a highly urbanized environment, then Katie barred the door. Everything in the city is going to be barred on CEQA. Among the arguments the court rejected was the notion that these new structures would attract graffiti and public urination. And to me, there's sort of a witty little passage where the court says there's no evidence in the record indicating that this sort of antisocial behavior would be particularly inspired by the presence of additional structures. In other words, if someone's inclined to do that, a little more visual clutter probably isn't going to be what puts them over the top. And I've talked about this case before, and then people ask me, suppose some great issue about dogs. And, there's just a straight correlation. More structures, more dogs peeing on them. And the court never reached that issue because the issue wasn't raised. It is true. Whether that logic would apply to him, he's got to stay right back. So I thought this was important just because, I think it represents the court thinking about, do we really want CEQA requiring EIRs for just total urban projects that are just dealing with small little structures? And you get the feeling that the answers are resounding. So there are a couple of neg deck cases. Haven't included them in all their glory. This Rominger case is interesting to me, although we're not going to go into it here. If for no other reason, the court applies the fair argument standard in a relatively stingy way. It's kind of commonplace amongst CEQA attorneys that the toughest case to defend is defending a neg deck, because the legal deck is kind of stacked against you. If the opponents hire an expert and that expert will opine the magic words, there may be a significant effect. It's pretty hard to defend against that, because courts have kind of a built-in bias in favor of EIRs. But here, the court didn't seem to behave that way. You read between the lines cynically, which is what I always do, because I think empirical evidence supports the generalist view of the conclusion. I think what happened here was this petitioner was not particularly sympathetic. It looked like two wealthy farm families in Volusia County battling it out. The Rominger family apparently was a business rival to the applicant here. So they raised all these issues, and they all got shut down with one exception, which was traffic. So if you're defending neg decks, it's good. To me, the most interesting part of it, though, is on the issue of prejudice. The court found some errors in notice documents, just flat out errors, and said, it doesn't matter. In one instance, the notice said that the planning commission hearing was going to be at 1:30 in the afternoon, and then a few days before the hearing, they changed it to make it 9 a.m. There was a guy who showed up at 1:30 wanting to talk, and the thing was over, and the court said, not prejudicial. He got to talk to the board of supervisors on appeal, and he never complained. It was just a volunteer complaint. Then they set the 30th day of the review period on Monday holiday, and because it was a holiday, you couldn't turn in your comments, and so it really meant there was a shortened period. It was less than the full 30 days, and the court said that didn't matter. So to me, it's a good case on error, not necessarily being prejudicial. The Citizens for the Restoration of L Street case is also a NICNET case, but it's we're going to talk about it here, not on fair argument, but because it basically is one of a number of cases which have created a notion you can't find in statute or in the guidelines, which has implications for the lawfulness of ordinances of the state. Basically, that principle is that the final decision maker on the merits of a project must also be the final actor on CEQA, and you can't separate those two. So here, as the Court of Appeal read the operative ordinance of the City of Fresno, the Historic Preservation Commission was the final actor on demolition permits for historic resources, subject to an appeal, but it only had commenting authority over CEQA. So it could comment on CEQA documents, but it didn't have authority to certify EIRs, negative declarations. And yet here it was the final decision maker, absent an administrative appeal. Building on earlier cases, such as Poet versus Air Resources Board from 2013, the court said it's just inherent in CEQA for it to get done properly, that the agency that's making the final decision on a project also must be the final actor on the CEQA documents. And in earlier cases, the fact situations involved a division of labor between staff and decision makers, or between various levels of decision making within agency hierarchy, and found that there's problems under both. In the Poet case, the problem had been that the Air Resources Board itself, the appointed board, had tentatively approved regulations based on just a draft EIR. The day after the comment period ran, they gave approval, kind of tentative approval, but represented to the world almost as final approval. And then they delegated to their executive officer, responding to comments, and then said to him, well, if there's anything in the comments you think require us to revisit our opinion, bring it back to us. And the court said that was inherently flawed. You couldn't separate the responsibilities of the decision-making body to decide on the merits of the project from the obligations to complete the CEQA process. Then there was a case, not mentioned in here, called California Clean Energy Committee versus City and County of San Jose, where the court found the City of San Jose's approach to be, as a body that's sort of to be problematic. And under that jurisdiction's approach, the Planning Commission always was the last word on the legal adequacy of EIRs. So regardless of whether activities were legislative or adjudicatory in character, and regardless of whether the Planning Commission was the final decision maker, subject to an informal administrative appeal, or was acting purely in advisory capacity, as it does for legislative actions, they were going to be the last word on that portion of EIR certification dealing with legal adequacy. And so you had a situation, as you had in that case, where the project was the general plan update for San Jose. You had the City of San Jose looking at the general plan update and being told that the adequacy of the EIR was already established, and they were not asked to opine on that. That was a given because the Planning Commission had already said that. And in that case, the court said you can't do that. For the City Council to be a decision maker, with full consciousness of its CEQA obligations, it had to be the one to look at that final EIR and make the determination of adequacy. So with that background, this case basically said you have to have decision-making authority both on the merits and under CEQA in the same body. And so here, basically, as in the San Jose case, the court said these ordinances were deficient. They had to be reviewed. So I think if the city attorneys and county councils around the state are watching, and they have ordinances whereby there's some sort of split in responsibility under under CEQA and on the merits, they're going to have to rewrite those ordinances. So this is a bit of judicial activism, and it's just thought to be sort of inherent in CEQA, that the same entities have to have all these responsibilities, but you'll look in vain in anything in statute or guidelines that says that. But it's pretty well established now. So for those of you in public agencies, if your ordinances allow that kind of split, then you might want to talk to your city attorney and bring these cases. Yeah.
Quick question on the question, you mentioned that there was an issue where the executive officer was not able to make final as opposed to it was the executive officer of the commission.
Yeah, this is the Poet versus ARB case from a couple years ago. And so the final actor on regulations is the full ARB. They're, by statute, the entity that has responsibilities for lawmaking function. They had a tradition of not finishing the CEQA process, but sort of adopting in kind of a semi-formal way with a little asterisk by it, that, you know, for sake of public consumption, adopting regulations before the CEQA process was done. And here it was like the day after the comment period was over. And they purported to delegate the completion of that rulemaking, the completion of the CEQA responsibilities to their executive officer. And the court found that was a violation of CEQA. They were the decision maker. They had to see the CEQA process through to the end. They couldn't delegate it to staff. So it'd be kind of like the city council deciding to approve a general plan amendment on a draft EIR and then delegating the planning director to complete the process and decide whether the general plan amendment should stand or not. So it's really, they acted too quickly. They didn't let the CEQA process end. They had no benefit of written responses to comments. So arguably, all the comments that people have put in on the draft document in that case could not have been read, one would think, and taken fully into account by the decision-making body, unless they happen to read everything in the So when you take all these cases together, it just seems very clear that the courts now are saying without flexibility that you have to have the same body be final actor on CEQA and on the merits. Now, there are the cases saying, in the context of state agencies and the University of California, that if you have a true legal delegation of authority, say from regents and university to some subcommittee, and that agency has power to approve a project, then they also could be the final actor under CEQA. But you have to have a legitimate delegation. So CEQA doesn't really care about how you got decision-making authority, as long as it's legitimate decision-making authority. CEQA is happy with that, but it just is now saying final CEQA responsibilities have to be with that person or body. There's another aspect of the Citizens for Restoration of Elm Street case, which might be worth a minute or two. Susan Brand-Hawley, who's the attorney who brought this case, tried to get them to rethink a decision she had lost before them several years ago, where they had said that the question of whether a resource is an historical resource for purposes of CEQA is itself subject to the fair argument standard. In other words, in her view, if the agency's cultural resource specialist says this building is not an historical resource, but her hired expert says it was, then she thought it should be treated as a historical resource. And then you go on and talk about the level of impact of that. There's actually a 6th District Court of Appeal decision where she won on that. 6 districts located over in San Jose. So you had a conflict between the 5th District in Fresno and the 6th in San Jose, and she asked the 5th to rethink, and they resoundingly said, no, thank you, we appreciate you bringing this back to us, but we agree with what we said originally. So we now have a split of authority, and we've had it for some time on this issue. My sense is, here we are, the 3rd District Court of Appeal has no time on this. The reasoning of the 5th is on this case is quite detailed. It makes a lot of sense. If you go back and look at that 6th District case, there's not a lot to it. They didn't go through the level of analysis that the 5th did. So my advice to my clients would be to treat the 5th District as the more compelling precedent. So now, onto the EIR cases. There are a whole bunch of them. There's some supplemental review cases mixed in here. I'm going to share some of the discussion here with Gary in a little bit on some of the cases. But so just foreshadowing where we're going and what we're not going to talk about right now. You'll find great detail in the 40-page slides and back materials. So you can see there's a bunch, and some of them have made it to this point. So this first one is a case about ag mitigation. And as of about 4 or 5 years ago, surprisingly, there were no Court of Appeal cases that squarely addressed the question of whether the use of off-site conservation easements to preserve existing agricultural land was a legitimate form of mitigation under CEQA. A lot of people thought it was very commonly used, but the courts hadn't really opined on it. And if you'd heard me talk about this at that time, I would get into depublished cases that had said one thing and unpublished cases that had said another. But happily now we're just dealing with published cases. So in 2013, we got a couple of cases that said, yes, that is legitimate mitigation. So that had been cleared up. This case asked the question whether you always have to do it, as opposed to having it just be one of the tools in the toolbox. And basically the court said, you don't always have to do it. And I think it's a pretty fact-specific determination. And as I read the case, the use of off-site conservation easements really wouldn't have added much, given the other mitigation measures. So this was a big surface mine where mining was only going to be occurring on a relatively small percentage of the large site. And one of the requirements was that there be a buffer area around the area being mined at all times. And besides that buffer area represented the equivalent of a 1-to-1 preservation easement over that area. So here's this area being mined, say it's X acres, and there's this floating buffer within the footprint of the ownership of the applicant. And that area couldn't be touched. It was going to be kept in ag. And because the ratio was about the same as the ratio would have been for an offsite area, essentially 1-to-1, it functioned like an on-site conservation easement. There were also mitigation measures that required that the areas to be mined be kept in ag to the last possible minute, then be restored to ag after the mining was over and reclamation occurred. And there's even a discussion of how in some areas the farming would be better after mining had removed a bunch of rock from the soil. So certain areas of the soil was pretty rocky, not very productive. The process of mining would take out all the rocks, and then the restored areas would actually be more productive. So under those facts, there was no need for conservation easements. So I wouldn't read too much into this case on this issue of, hey, blow off the conservation easements. I think really you had virtually the equivalent kind of mitigation here. So if you read this case together with some of the earlier cases, I think it's pretty clear that conservation easements on or off site are a legitimate form of mitigation. There have been a couple of cases, including this one, that have rejected arguments made by project components that a 1-to-1 ratio is not sufficient. And that's very helpful because until the courts had upheld 1-to-1, you had the following conundrum. Typically, you would find a significant unavoidable effect from the loss of agriculture, even with an easement in place, because the easement doesn't achieve no net loss of ag soils. It just preserves an amount of land equivalent to the amount of land being lost, so there is a net loss. So the safe significance call is to say significant unavoidable. And when you have a significant unavoidable effect, you're always asked to keep mitigating and mitigating as long as it's feasible until you get to less than significant. So a 1-to-1 doesn't get you less than significant, and a 2-to-1 might not get you less than significant. So why not do the 2-to-1? It's better than 1-to-1. Why not 3-to-1? Why not 100-to-1? So you can see the logic. As long as you're having a net loss, why not just raise the ratio to infinity? And the courts have kind of rejected that. They seem comfortable with a 1-to-1 ratio. So what I tell my clients is that if you're looking for a safe harbor here, that's probably it. There's enough cases holding 1-to-1 that if you just use a 1-to-1 ratio for an offsite easement or an onsite easement, you're probably going to be okay. Yeah.
So is that 1-to-1 against just mitigating unavoidable?
That's what I would say. Yeah. That way you don't litigate the question of whether you really can say less than significant based solely on preservation. Now, if you're in a neg deck, then you might have to stick your neck out on that. And I think in general, the smaller the amounts of land loss, probably the easier it is to make that determination. There's no magic number for a threshold. You lose a tenth of an acre, you're in crime zones, you can say with a straight face, that's not significant. 1,000 acres, probably a hard argument to make. So somewhere between those two numbers is a sweet spot where you can no longer say with a straight face, it's less significant. But if you're in a potential litigation context, I'd say the same thing. And certainly on an EIR, it's just too cost. But I think I'm handing this off to you now.
So I'm going to handle the next few cases. You're going to see a dramatic difference between Jim's presentation and mine. So Jim, when I misstate a legal principle, please jump in. I'm going to talk about these next two cases. They both come from San Diego. They deal with similar issues, but they deal with them differently. The reason why I'm talking about them is they both deal with climate change, and it's an issue that we deal with a lot. We're dealing with the fallout of the second case right now. And both of these cases, both in San Diego, have been appealed to, or they've been petitioned, I guess, petitioned for review is the right word, to the California Supreme Court. My prediction is that the first one we're going to talk about will not be taken up by the court, and the second one that I'll talk about will be taken up by the court. That's just my prediction. So, just a little bit of background. We all hear this, but it's worth at least repeating. In 2005, then Governor Schwarzenegger adopted Executive Order S305, which established goals for the state of reduction of greenhouse gases to 1990 levels by 2020 and to 80% below 1990 levels by the year 2050. So that was in 2005. In 2006, the legislature passed the Global Warming Solutions Act of 2006, AB 32, and that also had goals in it. It had a goal of greenhouse gas reduction to 1990 levels by 2020. And it stopped there, although it also included a provision that after 2020, the ARB shall work on continued reduction, whether that means more reduction, I don't know, or just the same reduction that they've achieved by 2020, and reporting back to the legislature on new targets. So that's what AB 32 does. SB 375, passed in 2009, deals with a lot of things: sustainable community strategies, regional transportation plans. It also establishes goals of just dealing with light trucks and automobiles, of hitting, again, the same 2020 level of greenhouse gases going back to 1990 by 2020, but then also establishing a separate goal for 2035. And I forget what the exact number is, but there is a goal for 2035. So keep that in mind as we talk about this a little bit. The first case is Sierra Club versus County of San Diego. So San Diego County adopted its general plan in 2011. When they prepared their general plan, the Attorney General's office commented very heavily on it. They were concerned that the project was going to promote sprawl, that there was no climate action plan, and that the general plan was going in the exact opposite direction that SB 375 was going in. So the county, in a mitigation measure, agreed to prepare a climate action plan. And here's where this case is different from the one I'm going to talk about next. The county, in its mitigation measures, agreed to the trajectory of S305. They agreed both to adopt a climate action plan that had enforceable reductions and to have those reductions in place for 2020, and then to follow that trajectory in S305 to 2050. And here I think this is a very, very important distinction for what I'm going to talk about in the next case. So that's what they did. They agreed to adopt those mitigation measures. And so they went ahead and did so. They prepared a climate action plan. But the problem with the climate action plan was it didn't have enforceable measures. There was a lot of discretion. There were some questions about whether or not you would actually be able to hit the levels that they established. There was a lack of enforceability because a lot of the measures dealt with what other agencies could do to reduce their greenhouse gas emissions. So, agencies that dealt with the city of San Diego, but nevertheless, they were responsible for their own actions. The second item that's raised here, by the way, and I just want to talk about it for a moment, but I'll get to it later, is one of the questions that was raised was whether a fair argument is involved in the decision of whether to prepare an addendum or a supplement to the EIR. For years, people have felt, and I believe I'm correct in saying this, Jim, that when you're dealing with supplemental environmental review, the question is there substantial evidence that a new significant impact would occur with the subsequent project? And in this case, the Sierra Club was arguing that no, it should be a fair argument whether or not your project is consistent with the project addressed in the up-tier EIR, and whether any new impacts would be significant, that this should be subject to the fair argument standard. This is a question that was placed before the court, and the court punted. And they punted because it felt like they didn't even need to address that, given the nature of what the climate action plan was saying. What did they do? First off, the court said that the climate action plan, because it did not follow exactly what the mitigation measure commitment was, enforceable reduction in measures, and following a 2050 trajectory, that it was a separate project. So you couldn't tier off the program EIR anyway. This was a separate project. It wasn't consistent with what the general plan said. It also said that because the climate action plan was not enforceable and didn't show reductions past 2020, that the mitigation measure, which said that if you do this, you would reduce your impact to less than significant, was no longer valid. That you now had a new significant impact. And so preparation of an addendum for a new significant impact is not appropriate. There was a case a couple of years ago, Lincoln Place versus City of Los Angeles, I believe it is, that dealt with this very issue. It was a project that involved redevelopment of an apartment complex in Venice Beach. And in that project, there was a relocation plan that was supposed to be implemented as mitigation for significant impact. And when they decided to implement the project, the developer went back to the city and said, you know what, it's too expensive to do that. We'd like relief. The city said, fine, you can have relief, go ahead. People sued, said that you mitigated this impact by committing to this mitigation measure, and the court agreed that if a project had a previous mitigation measure that reduced an impact, and you choose to remove that mitigation measure, then now you have a significant impact, what do you need to do? You need to prepare an environmental impact report because you have a new significant impact. Talked about some of this.
Here it's probably worth mentioning that this case also makes mention of the Colorado County Oak Woodlands case that was, I think, last year, associated with the cornerstone cost that they tried to do an MMP, if I remember correctly, associated with consistency with the general plan, and that was started out by the third public court. This court case actually brought her over that case.
Okay. There we go. So, the important issue here to me is not, it has very little to do with this executive order. The important issue here really has to do with following up on your mitigation. And so while this indicates the decision is problematic, and a lot of people have said it's problematic because the court frequently references Executive Order S305, the county had adopted that as a threshold. They adopted the county went ahead and said, we are going to commit to meeting the trajectory in this executive order. And because they did that, I think that they essentially bought into it. And as a lead agencies have discretion to establish their own significance criteria. And so they did. So I don't really think this is problematic. I think that the county went ahead and committed to this, to the executive order's trajectory. They essentially committed to the executive order. And what they didn't do was they didn't follow proper CEQA procedure, which is they decided to prepare an addendum, when in fact they should have prepared a supplement to the environmental impact report. Any questions on this? Okay, so now we're going to talk about Cleveland National Forest versus San Diego Association of Governments, which I think is the opposite. I think it is very problematic. So before I talk about this, I'm going to give you my non-legal read of what an executive order is supposed to be. So I went back and researched this. Executive orders are supposed to be, according to the governor's handbook, they're supposed to be a mechanism to enforce existing law. So if there are laws on the book and you need to interpret them in certain ways to enforce them, then you do an executive order. It's very similar to a presidential executive order. There's supposed to be a law in the book, and then you impose an executive order to carry out that law in a certain way. Well, think about it. 2005, what kind of laws do we have on climate change? Any? None. Well, what happened? So S-305, the executive order, is passed by the governor. It's signed by the governor, not passed. He didn't have anything to pass it to. It's him, right? It's governor. I'm king. I'm not going to sign this executive order. And then the legislature took that and they came up with AB 32. What did AB 32 do? It agreed with the first part of the executive order. Let's get to 2020, or get to 1990 levels by 2020. And then we'll figure out what to do after that. We'll report back to the legislature. SB 375 took it one step further. It endorsed the, at least as it relates to automobile emissions, the executive order for 2020, and then went on the trajectory to 2050 in establishing goals for 2035. That's what the intent of that was. So we have two pieces of legislation that said, you know what, we think the governor was right. We're going to follow his executive order, at least through 2035. Figure out what to do after that. So in that climate, SANDAG, San Diego County Association of Governments, adopted its regional transportation plan and its sustainable community strategies, which went to the year 2050 and certified the EIR. By the way, I think that the fact that they went to the year 2050 is where they created a lot of mess for themselves. Because if they would have stopped at 2035, maybe we wouldn't be talking about this. They prepared a program EIR, and it concluded that they would hit their 2020 targets, but there was a red flag. It said that after 2020, emissions would increase. So if you think of AB 32, it says you need to at least stay the same or go down in the future, depending on what ARB reports. So they were already reporting that they had a problem, that emissions were going to grow. They were sued by the Cleveland National Forest Foundation, and one of the arguments that was made is that the EIR should have looked at compliance with Executive Order S-305 for 2050. It should have evaluated getting to 80% below 1990 emissions by the year 2050. Well, SANDAG said, you know, this is a problem. There aren't any standards to compare this to. We don't have, there's no legislation. It's just an executive order. So how can we evaluate whether we're going to comply with programs when there aren't any in place? And the court said, well, you know what? You could have modeled this. You could have modeled how you can get to, or what levels you're going to get to by 2050. I think that's a problem, by the way, and at the end of my little summary here, I'll talk about why I think this is a problem, but let's stay with what the court is saying. By the way, this was a 2-to-1 vote. So courts of appeals are three judges. 2 of them agreed, one disagreed quite strongly. So Sandag adopted its own thresholds of significance. The court said, sorry, you missed one. You missed looking at 2050. And Sandag argued that, as a lead agency, we have discretion under CEQA, under 15064.4 or 15067 to establish our own thresholds of significance. We have greenhouse gas thresholds established in 15067.4. We followed those to the T, and the court said, that's fine, but these are not exclusive. They're not exclusive thresholds. So the way thresholds of significance language is written is these may be imposed. But there could be other information that is raised that you still need to look at when establishing whether or not you have a significant impact. We've known that all along. That's been a very important principle of establishing thresholds. If you have a threshold, but a fair argument is raised that perhaps there's another significant impact that your threshold doesn't cover, you have to evaluate that. Here, though, the court imposed this threshold on Sandag. It took Sandag's discretion away as lead agency. Another problem, and these are, I think, less important problems. Mitigation measures were not true mitigation. They were real easy to do. The ones that were adopted, the ones that were rejected were difficult to do, difficult to impose. So Sandag didn't have the will to impose these difficult ones. The court had problems with that. The EIR also didn't have a range of reasonable alternatives. It had 7 alternatives, but it didn't have an alternative dealing with this key issue of greenhouse gas emissions increasing past 2020. And the court felt that there should have been an alternative dealing with this, particularly an alternative that dealt with reducing vehicle miles traveled. Fair enough. Good issue. The court also found that the air quality analysis was insufficient. Jim's going to be talking about this later with this case on Fresno. But in effect, the court said, well, you quantified what the emissions would be. You said that what the threshold was. We talked about the fact that you have X tons and it will adversely affect air quality, that you're going to exceed thresholds. But you didn't say exactly what those health effects were going to be of the tons from your project on people. So there's a very important case. I'm not going to spend time on this. We're going to spend time on it later. Dealing with Bryant Ranch in Fresno. It deals with the effects of air quality on people and essentially asks CEQA practitioners almost to be doctors too. So that's something that we'll talk about later on. But just so you know, it came up in this case.
So was the main issue that they didn't adequately address their own thresholds that they had set? Or simply that the court didn't agree with the threshold? Because normally the thresholds aren't even set in law. That's why they're done at the local level.
Right. So the question is whether or not the court disagreed with whether they followed their own thresholds. So Sandag did follow their own thresholds. The court felt there should have been an additional threshold, dealing with 2050 emissions. One issue that's not up here is agricultural impacts were also found to be insufficiently addressed. I found this a little bit troubling. The issue was that the county Sandag looked at the farmland mapping program maps to determine how many acres farmland might be converted. And the appellants argued that, well, those maps are usually 10 years out of date. And in San Diego, most of the farms are below the size threshold, which I guess is 10 acres. I never knew this until reading this case. Is 10 acres, and most of the farms in San Diego are 3 to 4 acres. So they underreported the total number of acres that would be converted. So The dissenting judge sharply disagreed with the majority on all issues, and words that were used are by the dissenting judge is you are stripping lead agencies of discretion to establish their own threshold, which is a key component of CEQA. And my favorite was this insinuation of judicial power into the environmental planning process and usurping of legislative prerogative is breathtaking. I wonder if they went out for lunch afterwards. So the dissenting judge noted that S305 is not state policy. It's an executive order. And in fact, talked about the only case on record dealing with executive orders, which was Schwarzenegger's attempt to furlough employees. And in that case, the court said you don't have, this is not a privilege of the executive. This is something that the legislature does. So you don't have the ability to furlough employees on your own as governor. That's what the legislature does. It creates policy. Your job is to enforce that policy. So if a policy doesn't exist, you can't create it. In effect, what that judge was saying is S305 probably is unconstitutional. State inconsistent with the state constitution. Didn't quite get there, but he came close to saying that. He just said that it should just be looked at as a broad policy statement. So we now have this case, and the two judges win, 2-1, they win, that now says that S305 is an official policy that you need to address in CEQA documents. And you need to look at that as a possible threshold of significance, at least in the appellate district that they're located in. This presents a bit of a problem and a question. How do you address projects that are going to be completed post 2020? That's where we have entire control over the economy in terms of greenhouse gases. That's what AB 32 does. Or 2035, which deals with land use decisions and automobile and light truck traffic. We've looked at this, and if you do a climate change analysis now, you'll find that most of the emissions reductions that occur in a project, most projects are going to comply with AB 32, and the reason is because regulations have been established that address not only the project, but the entire economy, how it all works together, low carbon fuel standards, cap and trade, all kinds of things that actually address reduction in greenhouse gases. There's nothing past 2020. So how do we know whether a project will comply with this 80% below 1990 standards by 2050? There's no way, and no single project is going to do that. So then the question is every project significant that's going to be completed after 2020, or potentially significant, not avoidable? I think this is a real question that we have to wrestle with. The only bright spot is most of the projects that we address that are going to be completed that far in the future are big enough that they're already having environmental impact reports on them. So whether this pushes us from negative declarations to EIRs, I'm not sure that that's the case. But until this is decided at the Supreme Court level, and hopefully the Supreme Court takes it on and says, you know what, we disagree, we have to deal with this dilemma. Any questions on this?
So nobody's formally appealing that decision yet?
It has been petitioned to the Supreme Court.
Oh, it has.
Just haven't accepted. How long does it take normally, Jim, for the Supreme Court to decide?
Another 60 days, maybe.
So if they take it up, then the case no longer has application. If they agree with it, then it becomes law. If they don't, then it never existed. Great.
So my 2 cents on that case is that you all better hope that the Supreme Court doesn't take it out, because I was reading the case, and actually in my own head, I was thinking, this is breathtaking. And then when I got to the sentence, I said, she used the same word. I mean, it just, I mean, you learned the first day of law school that the governor does not have this power. It's just simple high school civics. The legislative branch legislates, the governor and the president are executives, and they enforce the law, don't make the law. Arnold Schwarzenegger just loved to issue executive orders, but he didn't have the power in 2005 to, by fiat, dictate a fossil fuel free economy for the state in 2050. And, you know, I reserve the right to be outraged at the judicial activism of right-wing judges, and so when I see it on left-wing judges, even if I'm sympathetic with the outcome, I have to be offended as a lawyer, and just the unlawful nature of the exercise. And to give the court credit, this was the Attorney General's office view, very aggressive view by the Attorney General's office, just on a mission to make it as hard as possible to approve projects without really aggressive climate change mitigation. But this one, Justice McConnell, the 4th District Court of Appeal, she just decided to be the policymaker for the state, and she's just decreed, essentially, that this executive order is the law of the state. And I really don't know how you do a critical analysis of the 2050 condition, because the whole premise of that target is that the entire world is basically going to get off fossil fuels by that date. You know, it goes back to the old IPCC recommendations from right around the time of the executive order. And how can you look at a project in California with our grid and our vehicle fleet and have an opinion about whether it's going to fit in the world in 2050? And then Gary raises the issue, can you neg deck something if you have to do a 2050 analysis on every project? And it's got cars that have internal combustion engines, and it's on a grid that in 2020 is only 1/3 renewable. How are you going to get a project decked in? So it just creates huge problems. Also, the project was a RTP, Regional Transportation Plan, with a sustainable community strategy associated with it. So this is now the standards that EIRs or RPPSCs have to follow. And the other parts of the decision are equally breathtaking. Do health risk assessments on a regional basis, one of the requirements. And this air quality correlation, if you have to tell me who's going to get sick in the region based on emissions occurring under a 20-year time frame, looking at the entire region of San Diego. So it should raise the bar so high, I think it's almost impossible to meet. So stay tuned. If it holds, along with the Lotus case we'll talk about later, it's probably the single case that will affect what you do as planners and consultants more than anything else. So these other cases are rather pedestrian in comparison. This one is a unsurprising case on piecemealing. The project here was some improvements on a dam in the state water project system operated by DWR. They started out with an EIR doing 2 seismic retrofit projects and then 1 project to reduce downstream flooding. When they started the EIR, they thought that was a logical lumping of things together. Then as they got to the end of the process, there were some issues about the improvements related to reducing downstream flooding that they decided to put that part of it on hold and just proceed with the seismic retrofit components. And then they got the argument that they were piecemeal. And the court rejected those arguments, essentially because even though it was okay to lump unrelated things together, you didn't have to lump them together. So when DWR decided to split off the flood control project from the seismic retrofit components, that was perfectly okay because they had different purposes. Each had independent utility. So the court just went through the sort of classic piecemealing analyses, and under all those analyses, the project was upheld. There's an interesting discussion of what it takes to obtain standing under CEQA. By statute, in order to have standing to bring a lawsuit, you have to object to the project. And DWR actually, I thought, had a good argument here that the petitioner never objected. He never said, I object to this project. Instead, he raised questions like, well, what about this? What about that? And And that's all he said. And the court said, well, that's close enough to be an objection. If you ask questions and are pointed in a sarcastic fashion, that's an objection. So that's not so much of interest to you. Piece feeling stuff is that it isn't really plowed new ground. It's basically an affirmation of independent utility, the need to look at the purpose of project components. And different components with different purposes can be processed separately if that's the pleasure of the agency. So this is a case about high-speed rail. It's a published case. A lot of the case in the very beginning deals with the issue of federal preemption. It's on the slides because it's not really CEQA. And the issue of federal preemption now on another case is in front of the California Supreme Court, so I'll talk about that towards the end of the day. The remainder of the case is all about the adequacy of the programmatic EIR that the High-Speed Rail Authority did in deciding which route to take into the Bay Area from the Central Valley. So essentially, the question was, do we go through Pacheco Pass and then up into the, through San Jose and up into the peninsula to San Francisco, or do we go through the Altamont Pass and then have to build a bridge across the bay to get to San Francisco and then a separate spike going down to San Jose? So this EIR was the mechanism for making that choice. Ultimately, the decision was made to come up through the peninsula. Predictably, people who were in the path of various routes weren't too enthused about the train coming through their area, so they hired consultants to recommend different routes, to pick at the routes that were in the EIR, and then to offer suggestions about where to go, not in the backyard, with people who hired consultants. And then in all instances, the court rejected the argument, essentially on the theory that there was substantial evidence to support the decisions of the High-Speed Rail Authority. So it's really not that valuable a precedent, except it's a good example of the program EIR being upheld and not having to drill down too deep into the details of particular routes. It was really about route choice. One of the arguments was there were some issues with elevated platforms somewhere in the peninsula, and the court said they're not there yet. They're going to do site-specific EIR for that route. Once that route's chosen, this is just an EIR to choose the route. So it's a good case if you're defending a program EIR because the court's pretty deferential based on the substantial evidence standard. This case is another good case for respondents. This project is a big mixed-use project in Treasure Island in Yerba Buena Island, right in the middle of the Bay Bridge, basically. The EIR was a project-level EIR, and the primary argument was it should have been programmatic because the project was not really well defined, but had some flexibility built into it. So the opponents argued as a matter of law that any project that maintains that flexibility can't be done with project EIR because that's the only CEQA document there may be, and we need to know what the project is. And the court rejected that. Basically, this project wanted to maintain flexibility to have more or less residential, more or less office, more or less retail, depending on market conditions. So what the EIR did was to look at worst-case scenarios for particular impact categories, reflecting the use scenario that would be the most impacting. So for traffic, for example, you'd find the combination of uses that generate the most peak hour traffic. For other types of impacts, you'd look at other scenarios where the worst case scenario would arise in terms of water demand, wastewater generation, all those things. So they had it covered, and then they had very detailed standards for development. So even though there was a lot of flexibility, once the choice would be made based on market conditions to go with one set of uses rather than another, there were very specific standards that made sure those uses were built in a way that had some good design or good issue built into it. So basically, that was the thrust of the case. You just can't do this on a project EIR. There's useful language in the case talking about the discretion a lead agency has in deciding whether to do a project or program EIR. It says the standards are essentially the same, and that is you do what is reasonably feasible under the circumstances. You use the information you have to fully explore all reasonably foreseeable impacts, and by calling it a project EIR, You don't have an obligation to change the underlying nature of the proposed project to be more specific. If you're looking at a flexible project, you can do a project BIR. You just take the project as you find it, you do your best, and always it's reasonable. So there are some other subsidiary issues, but that's the most important aspect of it from my standpoint of running out of time. Here's a case that represents, question, yeah.
For that same case, do you think if it was a negative declaration that the finding would have been the same versus partial BIR?
That's such a hypothetical. I mean, it's way too big a project to on neg deck. So my guess would be that if someone wanted to blow up that neg deck, they could have found an expert to do it. And there is no distinction between a project level and a program level neg deck. There's only project and program level EIRs. You can do lower tier neg decks off of program EIR.
Right.
There was one case 20 years ago that invented a programmatic neg deck, just kind of in the old-oriented fashion. But you don't see any reference to that in the law. Judicial fabrication. This case, I think, is interesting in that it represents how useful the rules of subsequent EIRs and it could be to an agency that really doesn't like doing multiple EIRs in a single project. The project here was the airport master plan in San Jose for their international airport. It was done in 1997. This was the 8th addendum they did to that. So they supplemented it in the early aughts, and then since then, as they tweaked the configuration of hangars and various airport structures, they've done addenda. And the court found that was appropriate here. And basically, the standards on the supplemental or subsequent reviews, you have to have new significant facts or substantial increase in severity previously identified as facts to force the preparation of supplemental or subsequent. And the facts here didn't support that. They were working within the envelope of the impacts of build out as looked at in the EIR and the supplemental EIR, and they didn't get any worse. They were just as impactful or less. And one of the things that's happening down there is that the noise impacts are going down, in part because the fleets are getting quieter, new airport design requirements, but also San Jose is not having as much air traffic in terms of jumbo jets. There's a greater number of Lear jets for private billionaires coming in and reduction in commercial flights. So if you're defending an addendum, this is your case. You can say, look, we're only in our 4th addendum. These people didn't. This case, I know I'm running out of time here. This is another zinger. And I'm going to focus on the use of Appendix F here. This is a local project. It was the second phase of a retail project in Woodland. Big box oriented and with ancillary uses. The project is approved as a smaller version of what was originally proposed. The court found problems with a bunch of mitigation measures related to urban decay. Very stringent view of mitigation measures, even for significant unavoidable effects. The court was really fly-specking the mitigation measures to standards that I would have thought only really applied where you were claiming mitigation got to less than significant levels, but the court didn't seem to think that was an important distinction, so it really raised the bar on mitigation. But the Appendix F discussion, I think, is the most significant. In 2010, with the changes to the CEQA guidelines dealing with greenhouse gas emissions pursuant to SB 7 from 2007, I believe, the Resources Agency modified Appendix F, which had been there for a long time. And they infused it with language showing concern about climate change. So it had always been about energy, but now it's about energy, and in particular fossil fuel energy, and identifies fossil fuel as needed to be overcome in California. And the inventive thing here this court did was to treat Appendix F as though it was mandatory, and to find the EIR to be deficient for a number of reasons, for failure to do adequate energy analysis. For example, the EIR made a big deal about how the big box component was going to be consistent with green building codes. And there's kind of a tendency when you're dealing with a Walmart or a Costco to focus on that structure. But there was no discussion of how about all the other fast food joints and all the other little tabs. No discussion about how green they would be. But the most startling thing was the court said there was no quantification of the amount of fossil fuel used by people coming to the project site. So imagine if you're doing an EIR at a Walmart, for example, maybe in the city of Rockland, for example, this is all past tense, and you didn't quantify the number of gallons of gasoline that trucks delivering goods would bring and customers would bring. And you didn't try to determine whether there were alternatives to the use of that fossil fuel. Well, that's what the court said you need to do here. So quantify fuel usage. And this is on top of, you're already doing an air quality analysis, you're already doing a traffic analysis, you're already doing a GHG analysis. And they want to know how many gallons of gas. And I'm not sure what you're supposed to do with that information because I don't know that you can dictate, and I'm sure that retailers would not want to do this. You can only shop in our store if you drive an electric car. Otherwise, they don't want your money.
Well, actually, Jim, there's very helpful guidance in the exam. It asks whether or not it's wasteful use.
That's the question.
So, just all you have to do is decide whether using that many gallons of gas is wasteful or not.
I think the court here was looking for that. I think the court here thought that this was a bad location. This was a big box on the edge of the retail, edge of the urban area. The urban decay part of the discussion showed that the downtown people would suffer. And so there's a lot of EMT associated with people shopping in this location, and the court seemed troubled by that. And I think she was looking for a way to force an analysis of that, and maybe use the fuel consumption as a basis for asking, is this the right location for this kind of use?
So is then the focus of this energy use relative to some alternative, as opposed to an absolute analysis?
It doesn't say. It says quantify it, and maybe you find it's wasteful, and if it's wasteful, what are you going to do about it? Don't build a project.
Was the significant conclusion on urban decay that it was significant and unavoidable?
Yes, in the short term, and then it would all be okay in the long run. So with that finding, there were a bunch of mitigation measures that didn't reflect the same level of discipline that mitigation measures would be written for less than significant impact. In other words, they didn't have performance standards you had to get below. They were a little sloppy about asking the applicant to generate information without having it routed through the agency so that they could exercise their independent judgment on it. So the court looked at all these mitigation measures as though they were being cited for the proposition that they could reduce the impacts to less than significant. So arguably, it's bad public policy because now if you have a significant unavoidable impact and you're thinking about writing mitigation measures, you need to live with fear of this court if you didn't do it perfectly. So maybe you're going to be inclined to write them as conditions of approval so you don't get, thrown into glass for not writing the perfect mitigation measure on significant unavoidable.
Well, I find it very troubling, the very question, and it's been there for a long time, the question of whether or not your project will result in a wasteful use of energy. I'm not sure what that is. Does that mean that it's not an absolutely essential project? It's a home that people must live in. If it's not that, if it's a new arena in downtown, is that a wasteful use of energy? Because who really needs to go do that? It adds a lot of personal, social judgment into how you evaluate these things. And I think CEQA becomes very difficult. And we're going to talk about this a bit later with SB 743. I think CEQA becomes very difficult when we have to bring social judgment into a hard analysis of facts and then applying whether or not we've got a problem or not. No answer that.
So this is another pitfall to avoid. So when you're doing your 2050 analysis, be sure to quantify the gallons of gasoline on the delivery truck. And then try to mitigate for that sometimes. If you had each shopping center be a renewable energy facility that offset all the cars coming in, maybe that's a solution. So drive to the Walmart / solar field and do all your shopping and be guilt-free because your emissions will be offset by the solar power that's being generated by that.
I think the answer, Jim, is all Walmart should be next to you. There should be housing on top of the Walmart. So they don't have any people charges downstairs. Why would they need to go upstairs? Maybe you get their jobs there too.
I think there's a dystopian novel of the future. Just going to wrap up soon before our break. There is a case under the category of certified regulatory program. It is really fact specific, and unless your practice involves marble and mural land mitigation on a daily basis, I don't. For some reason, California Department of Fish and Wildlife wanted this published. There's a CEQA aspect to it that they like, and the CEQA stuff is all pretty spectacular. Then there's a bunch of litigation cases I'm sparing you. If you really aren't looking for this sort of thing, there's painfully detailed slides of fighting the very end. For local people, the Sultan 12 case might be of interest. This was the rejection by the Court of Appeal of the notion of the provision of SP 743 saying that there can be no injunction against the Kings Arena absent public health and safety considerations or Indian burial ground that was constitutional. So we're still hoping that by 2017 that new arena will be in place and our team might be at 500 with this new coach. So let's take a break and come back at maybe 5 of, and we'll start in a second.